Jefferson County Court at Law number 2 is back in session. The court is in session in cause number M333-686. The case is styled the state of Texas versus Victoria Laura Smith. Let the record reflect that Ms. Smith is now present in the courtroom with her attorney, Attorney John Macy. Let the record also reflect that the state is present with Assistant District Attorneys, Attorney Andrew Hewell and Attorney Haley Simmons. Let the record reflect that the jury is now seated and present in the courtroom. At this time, ladies and gentlemen, I will read to you the court's charge containing the law applicable to this case. The defendant, Victoria Laura Smith, stands charged by information with the offense of abusive calls to 911 service, alleged to have been committed in Jefferson County on or about the 20th day of August 2022. To this charge, the defendant has entered a plea of not guilty. A person commits an offense if the person makes a call to 911 service or requests 911 service using an electronic communication device when there is no emergency and knowingly or intentionally makes abusive or harassing statements to a PSAP employee. 911 service and public safety answering point, or PSAP, have the meaning assigned by section 771.00, I'm gonna say it should be 772.001, Health and Safety Code. Public safety answering point means a continuing operated communications facility that is assigned the responsibility to receive 911 calls and, as appropriate, to dispatch public safety services or to extend, transfer, or relay 911 calls to appropriate public safety agencies. A person acts intentionally or with intent with respect to a result of their conduct when it is their conscious objective or desire to cause the result. A person acts knowingly or with knowledge with respect to a result of their conduct when they are aware that the conduct is reasonably certain to cause the result. Therefore, if you believe from the evidence beyond a reasonable doubt that the defendant, Victoria Laura Smith, did in Jefferson County, Texas, on or about the 20th day of August 2022, did then and there make a telephone call to 911 when there was not an emergency, and Victoria Laura Smith knowingly and intentionally make abusive or harassing statements to a public safety answering point employee whose meaning is assigned under section 772.001 Health and Safety Code, then you will find the defendant guilty of the offense of abusive calls to 911 service as charged in the information, unless you so find beyond a reasonable doubt, or if you have reasonable doubt thereof, you will find the defendant not guilty. General instructions. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The fact that a person has been arrested, confined, or indicted for or otherwise charged with the offense gives rise to no inference of guilt at the trial. The law does not require a defendant to prove innocence or produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt after careful and impartial consideration of all the evidence in the case. The prosecution has the burden of proving the defendant guilty, and it must do so by proving each and every element of the offense charged beyond a reasonable doubt. And if it fails to do so, you must acquit the defendant. It is not required that the prosecution prove guilt beyond all possible doubt. It is required that the prosecution's proof excludes all reasonable doubt concerning the defendant's guilt. You have a right to consider all the facts that are shown by the evidence and to draw natural and reasonable inferences from such facts. You alone have the authority and duty to determine what the facts are. In evaluating the evidence, you must totally disregard what you believe is my opinion about any factual matter. You cannot question a bailiff concerning the testimony or the law, nor should you discuss the case in her presence. If any question develops during your deliberation, it must be reduced to writing, signed by your foreperson, and given to the bailiff. The question will then be answered by the court as soon as possible to the extent allowed by the law. Questions and comments of the attorneys do not constitute testimony and must not be considered as evidence. You must also disregard any statement of the attorneys that is inconsistent with the law contained in this charge. Any physical exhibits admitted into evidence will be furnished to you by the bailiff upon your request. You must not consider facts that have not been introduced into evidence or legal principles not contained in this charge. It is improper for you to discuss or consider anything which you know or have learned outside of the testimony presented to you and the law contained in this charge. If you should discover that you have any outside information, you should not mention this information to any other juror, nor consider it yourself in arriving at a verdict. You are the exclusive judges of the facts proven, the believability of the witnesses, and the weight to be given their testimony. However, you must be bound and strictly follow the law contained in this charge. Your failure to follow the law could result in a mistrial being declared, and your deliberate violation of this charge could subject you to being held in contempt of court. After the attorneys present their arguments, you will retire, select a foreperson, and consider your verdict. The arguments are not evidence, and you should give the arguments only the consideration you feel they deserve during the evaluation of the evidence. It is the duty of your foreperson to make certain that your deliberations are conducted in accordance with this charge. After you have reached a unanimous decision, your foreperson should sign the appropriate verdict attached to the charge. In returning your verdict, it is your responsibility to make certain that justice is done in this case. The last phase of discharge is the verdict form. And you notice that there are two lines on the back page. If your verdict is, we, the jury, find the defendant not guilty as charged in the information of abusive calls to 911 service, then your foreperson will sign on the top line. Or if your verdict is, we, the jury, find the defendant guilty as charged in the information of abusive calls to 911 service, then your foreperson will sign on the bottom line. Does everyone understand? Yes. I'm sure everybody nodding in your heads. Everyone understands? At this time, we will move to our closing arguments. State, you have the right to open and close. State, are you ready?
State's ready.
Defense, are you ready?
The defense is ready, but I would like to approach briefly, Judge.
Okay.
Just to find out which.
Hold on a minute. Can everyone please stand? Okay, everyone may be seated. Let the record reflect that court has reconvened and calls number M33686, case is style of state of Texas versus Victoria Laura Smith. Let the record reflect that Ms. Smith is present in court with her Attorney John Macy. State is present with Assistant District Attorneys Andrew Hubel and Attorney Haley Simmons. Let the record also reflect that the jury is present and seated in the courtroom. Now, ladies and gentlemen, the jury going to reread the charge. This charge will be given to you when you get back in the courtroom. I mean, back into the jury room. And it reads as follows. Charge to the court. Members of the jury, the defendant, Victorious Laura Smith, stands charged by information with the offense of abusive calls to 911 service. Alleged to have been committed in Jefferson County, Texas, on or about the 20th day of August of 2022. This charge, or to this charge, the defendant has entered a plea of not guilty. A person commits an offense if the person makes a call to 911 service or requests 911 service using an electronic communication device when there is no emergency and knowingly or intentionally makes abusive or harassing statements to a PSAP, as PSAP, employee. 911 service and public safety answering point, or PSAP, PSAP, has the meaning assigned by section 771.001, the Health and Safety Code. Public safety answering point means a continuously operated communications facility that is assigned the responsibility to receive 911 calls and, as appropriate, to dispatch public safety services or, to the extent, transfer or relay 911 calls to appropriate public safety agencies. A person acts intentionally or with intent with respect to a result of their conduct when it is their conscious objective or desire to cause the result. A person acts knowingly or with knowledge with respect to a result of their conduct when they are aware that the conduct is reasonably certain to cause the result. Therefore, if you believe from the evidence beyond a reasonable doubt that the defendant, Victoria Laura Smith, did in Jefferson County, Texas, on or about the 20th day of August of 2022, did then and there make a telephone call to 911 when there was not an emergency, and Victoria Laura Smith knowingly and intelligently, or knowingly and intentionally, make abusive or harassing statements to a public safety answering point employee, whose meaning is assigned under section 772.001 of the Health and Safety Code, then you will find the defendant guilty of the offense of abusive calls to 911 service as charged in the information, unless you find beyond a reasonable doubt thereof, excuse me, unless you find beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will find the defendant not guilty. General instructions: the persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The fact that a person has been arrested, confined, or indicted for, or otherwise charged with the offense gives rise to no inference of guilt at the trial. The law does not require a defendant to prove innocence or produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant unless the jurors are satisfied beyond the reasonable doubt of the defendant's guilt after careful and impartial consideration of all the evidence in the case. The prosecution has the burden of proving the defendant guilty, and it must do so by proving each and every element of the offense charged beyond a reasonable doubt. If it fails to do so, you must acquit the defendant. It is not required that the prosecution prove guilt beyond all possible doubt. It is required that the prosecution's proof excludes all reasonable doubt concerning the defendant's guilt. You have a right to consider all the facts that are shown by the evidence and to draw natural and reasonable inferences from such facts. You alone have authority and duty to determine what the facts are. In evaluating the evidence, you must totally disregard what you believe is my opinion about any factual matter. You cannot question the bailiff concerning the testimony or the law, nor should you discuss the case in his or her presence. If any question develops during your deliberations, it must be reduced to writing, signed by your foreperson, and given to the bailiff. The question will then be answered by the court as soon as possible to the extent allowed by the law. Questions and comments of the attorneys do not constitute testimony, and you must not consider it as evidence. You must also disregard any statement of the attorneys that is inconsistent with the law contained in this charge. Any physical exhibits admitted into evidence will be furnished to you by the bailiff upon your request. You must not consider facts that have not been introduced in the evidence or legal principles not contained in this charge. It is improper for you to discuss or consider anything which you know or have learned outside of the testimony presented to you and the law contained in this charge. If you should discover that you have any outside information, you should not mention this information to any other juror nor consider it yourself in arriving at a verdict. You are the exclusive judges of the facts proven, the believability of the witnesses, and the weight to be given their testimony. However, you must be bound by and strictly follow the law contained in this charge. Your failure to follow the law could result in a mistrial being declared, and your deliberate violation of this charge could subject you to being held in contempt of court. After the attorneys present their arguments, you will retire, select a foreperson, and consider your verdict. The arguments are not evidence, and you should give the arguments only the consideration you feel they deserve during the evaluation of the evidence. It is the duty of your foreperson to make certain that your deliberations are conducted in accordance with this charge. After you have reached a unanimous decision, your foreperson should sign the appropriate verdict attached to the charge. In returning your verdict, it is your responsibility to make certain that justice is done in this case. This is the verdict page. You notice two lines, one at the top, one at the bottom. Above the line at the top, it states, "We, the jury, find the defendant not guilty as charged in the information of abusive calls to 911 service." If that is your verdict, your foreperson will sign on this line. Or The next statement below states as follows: we, the jury, find the defendant guilty as charged in the information of abusive calls to 911 service. If this is your verdict, then your foreperson will sign on the bottom line. Does everyone understand? Okay. At this time, State, are you ready?
Thank you.
Defense, are you ready? Okay, and Mr. Macy and Mr. Hubel, is 15 minutes enough, or do you need more time?
I think that seems a bit, Your Honor.
15 minutes? Okay, and I'll be keeping time. At this time, the state has the right to open and close. Mr. Hubel,
State leaves its right to open, reserves its right to close.
okay. And Mr. Macy, you may proceed. Ms. Mosley, could you turn the table toward the jury? Thank you. And Mr. Macy, I'm keeping time. I'll let you know if you have 5 minutes left.
Thank you. We're finally to the end of this trial where now you know what the state has to prove. You've already heard the evidence. And so, you know, and so now you apply. And before I go further, I wanted to say, I really appreciate, and I'm sure Mr. Hughes and Ms. Simmons and the judge appreciate your attention all the time you spent here. Without you, citizens that are willing to come and do this, we can't do this process. So we appreciate that. So the question you have to answer is, did my client, Victoria Smith, violate this statute that she's charged with? And I'm gonna first off submit to you that you have to remember that the state has the burden of proof on this case. I don't have to prove. So what they have to prove beyond reasonable doubt is, as the charge says, each element of this case. And the elements of this case, number one, are that the call that she made wasn't an emergency. And if they can manage, now I think that they didn't prove that. It was an emergency. That's why she called. He scared her. She thought he was gonna take her kids away. Her kid, he and her have a child. He doesn't have custody rights in that child. And she could, you know, be one of those types of people that say, no, you don't get to have any access to your kids, but she's not like that. She testified to that. She gives him access, even now, even after he's done all this stuff to her. She tried to give him access when it's appropriate and available. But when he starts threatening her and doing things like she testified to, then it's like, wait a minute, I'm gonna call 911 again because she's done it before. She called 911, she testified. You know, I was arguing with the not arguing, but I was trying to get them to explain to me the difference between how many times she called. And they were saying, oh, she called 3 times. And I was saying, well, was it 4 times? Well, she testified. She said, I called about 8 times that day. They wouldn't respond, they wouldn't come. And it wasn't her first rodeo, so to speak. She'd been down that road before. She'd called when she had a problem. And they decide, well, maybe, you know, they weren't in any kind of big hurry to get there. Well, in the meantime, what was he doing? He was you know, threatening her, he was, you know, damaging her property. He was doing a lot of things that she testified to. And so what's she supposed to do? Because I asked the 911 call, well, what types of calls do you get as a 911 operator? She goes, well, all kinds of calls. She listed some of them. And she said, well, you know, if it's auto theft or assault or trespass, which in this particular case, they were claiming, well, that's what she complained about, trespass. Well, yeah, should she have also said some other things about, hey, you know, he's damaging my property. He's trying to take my child and all this stuff. Maybe she should have, but she didn't. But does that mean that it didn't happen? And who decides it's an emergency? Her? You know, or is it them? Do they get to decide after the fact? Well, we're going to say she violated the statute. But the only way she can violate the statute is if they prove that it wasn't an emergency. Because if it was an emergency, it doesn't matter whether or not she made harassing or abusive statements to the 911 call. Now, I'm suggesting that she didn't. She might have made some statements that you don't like, or that I don't like. She didn't like in retrospect, but she was mad at the time, and she made some statements that she said that, you know, I probably shouldn't have made, but she was getting irritated. She was irritated because she'd already called them before. And when they bother to come around there, now I say that, don't misunderstand what I'm saying. Police officers have hard jobs, okay? And they protect us. Officer Garcia said he was a patrol officer for 15 years. We need him, okay? But in this particular case, he said, well, look, I've gone to them, you know, she's called, I've been to that house before with them having these problems, okay? Or having problems. He denied knowing about the trespass warning, okay? But I asked him about that anyway. I said, well, did you check whether he had a trespass warning? No. And I said, well, if there was a trespass warning, what would you have done? Nothing. Because when I got there, he wasn't on her premises anymore. Okay, well, she's been down that road. That's why she was calling 911 in the first place. Hey, he's here. He's doing this stuff to me. Come here. He's here. Come and get him. And then I'm going by and calls him again. Where are you? And then she calls him again. Now, I was thinking, based on some things that I thought I knew, you know, that maybe there's more calls. Because that's what they admitted into evidence. Well, they only admitted 3 of them, right? And then I was saying, well, was there another one? Because on the first one that they admitted, you can hear it, you can take it back there and listen. When she calls, the officer said, the PSPAP, the dispatcher, 911 dispatcher said, we already have your call. So they already knew she called on that first call that they admitted into. But she testified, no, it was more like 8. I started calling at, 5:30, 6 o'clock in the morning. Now, they didn't produce those for some reason. I don't know why, because you would think they would, but they didn't. But she said that she was calling the moment he started banging on her door when she found out he was on her premises. Now, of course, he said, well, I was sleeping upstairs, but that upstairs is still connected to her, is on her premises. So they have to prove that it wasn't an emergency, okay? I don't have to prove that it was an emergency. We don't have to prove that. We don't have to prove anything. But especially I don't have to prove that it was an emergency. They have to prove beyond a reasonable doubt that it wasn't an emergency. Okay, I don't think they did that, or they can do that. Because think about, I want you to think about the statute, because you're gonna have it, because it's what they have to prove. The statute says a person commits an offense if the person makes a call to 911 services or requests 911 services using an electronic communication device when there is no emergency and knowing or intentionally makes abusive or harassing statements to a PSAP employee. That's the statute that says she violated.
Makes you have 5 more minutes.
Thank you. So think about the legislature who wrote that. What were they trying to prevent when they said this is a criminal act? Well, I'll tell you what I think they were doing. They were trying to prevent a person making prank phone calls to 911, for lack of a better term, okay? In other words, there's not an emergency, but I'm making a call and I don't say anything. Okay, because that's the first way that the statute says you can be in violation of that statute. The second way is it's not an emergency. And the person intentionally or knowingly made abusive or harassing statements to the 911 operator, okay? What were they trying to prevent? They're trying to prevent prank calls, not legitimate calls like hers that she had a reason to call for. That's what they were trying to do. They're not trying to prevent that. And that's why those are legitimate calls. I asked the 911 operator. Those are the types of calls they get. Trespass calls or more serious calls. Now, arguably, based on the testimony, more serious things were happening. She didn't talk about that. And she didn't complain about that when the officer got there because she was so irritated that they took so long that she didn't want to talk to him anymore because she knew that because Mr. Lassane was not on the premises anymore, they weren't going to do anything. And she was irritated about that. And that's why she got more mad. But anyway, so I submit they have to prove that it wasn't, that she didn't have a legitimate reason to call. That part of their proof is that there was no emergency when they made the call. And then I don't think they can do that. And then lastly, they also have to prove, even if you believed that there was not an emergency.
2 minutes.
And in her mind, it's the emergency. That's whose minds it's important to. Because otherwise, because that's the one they gauge that on as to, is the person intentionally or knowingly doing a harassing calls or making prank calls? It's the person that's doing it. Well, if she thinks she's not, if she's legitimately calling them because she's scared, like she testified to, her daughter said she was scared. She was there too. Her daughter was scared. So all these people are scared, but they think, oh, well, it's not an emergency. So we decided, because we're tired of going out there, because she keeps calling us. When we don't arrest them anyway, they don't understand why she's mad. I don't think they proved their case, but.
Yeah, one more minute.
Thank you, Judge. I appreciate you listening to me. Take this into consideration when you go back there. I think that when you do and apply the evidence to the charge, you'll find that my client got it. Thank you.
Mr. Hubel, you may proceed.
Thank you.
I'll be keeping time.
First of all, I want to thank you all for your patience and attention this week. It's been much appreciated. Justice system cannot do what we need to do without y'all here. So briefly, I want to touch on defendant's case in chief before going into the elements of this case. Now, the defense presented 3 witnesses: Ms. Victoria Smith, Ms. Luciana Richard, and Mr. Rudolph Hussein. Each of these individuals has an interest in this case to be distruthful. Now, we talked in board matter about the credibility of witnesses, and we generally agreed that each witness gets equal credibility until they take the stand and say what they have to say. Now, in regards to Mr. Hussein, he testified to several things. That he had a relationship with a defendant that resulted in the child, Zariana. They had a child together. So in order to keep their relationship intact, he has a material interest in testifying in their favor. He also has pending terrorist threat charges with Ms. Victoria Singh as the complaining witness. So with charges over his head and defendant Ms. Smith as the individual who could move forward on those charges, it'd be in his best interest to testify in their favor. And whenever we played State's Exhibit number 4 for Mr. Hussein, after he had told us what his recollection of that date, his story that he told in the stand was incongruent with what's in State's Exhibit number 4. You'll have the opportunity to review that whenever you deliberate, and I'm going to do so. Now, as per Ms. Smith and Ms. Richard, their interests are more obvious. Ms. Richard is Ms. Smith's daughter. So, of course, you would want to speak in her mother's best interest, and Ms. Smith, as a defendant in this case, would want to speak in her own best interest. So, in regards to the elements that the state would have to prove beyond a reasonable doubt, there are several elements that are essentially agreed to that Ms. Smith, in fact, in her own testimony, admitted to on the stand. These are that this occurred in Jefferson County. This was proven by the officer's testimony, by the video in State's court, and by Ms. Smith's testimony, as was the fact that this alleged conduct occurred on August 20th of 2022. Officer Garcia identified the defendant, Victoria Smith, in the courtroom, and Ms. Smith admitted to making a 911 call on that day. This, in combination with Dispatcher Gray and Officer Garcia's testimony, proves the element of making a 911 call. So on to the point of knowingly intentionally making abusive or harassing statements. The knowingly intentionally element is inferred by the defendant's conduct in this case. She was on a telephone call with Ms. Gray, so naturally she knowingly spoke those words and intentionally conveyed those words to Ms. Gray, who found that language abusive towards her. Just to remind you what was said, Ms. Smith insinuated that Ms. Gray was stupid. She called her a dummy, and also accused her of having an attitude and being a white bitch. So on the stand, I had the opportunity to ask Ms. Smith if she regretted those actions. She said that she did, but her remorse only went so far, and in regards to, the statements about Miss Gray being a white bitch, she was kind of cagey about whether she agreed that conduct was abusive or not. She said that she says it all the time, and she justified the use of that phrase by the fact that she has a biracial daughter, which, I didn't truly understand the logic in that case. I think it's clear that, insinuating someone stupid, calling them a dummy, or using derogatory and racially charged language, are abusive in nature. Now, in regards to whether or not Dispatcher Gray is a PSAP employee, her testimony established that she worked for the Beaumont Police Department. She also testified that the Beaumont Police Department is continuously operated. It receives, and is the primary recipient of all 911 calls in the Beaumont area. It serves Beaumont, Texas, the jurisdiction that's located, and they are a dispatcher of public safety services. So that so all that together satisfies the definition of PSAP, or the public safety answering point, and that she also testified that she was an employee of BPD at the time of this offense. So that leaves the element of the emergency, which is another element that will be inferred by conduct. So, referring back to the 911 calls, which you'll be able to listen to in State's Exhibits 1 through 3, you can see that as the calls go on, she has a tone of agitation rather than fear. The frequency of the calls is consistent with her abusing the service, tying up the line. And in fact, she inquires as to whether Mr. Lasaint had also called 911. That's not pertinent to her emergency situation. She just wants information on whether or not Mr. Lasaint called, because they're in a spat now. So when officers actually arrive, Officer Garcia goes to the doorstep of Miss Smith, and she shoos him away whenever he attempts to respond to the call. Now, we spoke in voir dire and or in jury selection, and generally agree that in an emergency situation, an individual, especially whenever they're feeling like they were in danger or their property was in danger, that they want to make a report, that they want to talk to an officer. She did neither of those things that day. And that she did not make a report. She did not speak to the officer. She did not speak to Officer Garcia at her door. She said shoos him away, despite the fact that she knows that Mr. Lasaint is across the street still. So she does not have concern that he's still there. In fact, she comes outside and starts yelling at the officers, using more derogatory language towards law enforcement whenever she comes out of the home. So the tying up the line with multiple calls, then the line of the dispatcher with the derogatory language that she used, in diverting 3 officers from their duties. Also, she can turn them away at the door. That is the type of behavior that this statute was designed to prevent. And it has the same effect that Ms. Smith's conduct has the same effect as the prank calls that Mr. Macy was talking about earlier. Now, I ask you, after going one by one with the elements, I ask you to examine the evidence before you. The testimony, if you want to look back at testimony, you will have to request specific sections of that testimony. You can't just get the entire transcript of the record. So if you need to specifically ask about something, you give that instruction to the bailiff when you're in the deliberation room. And you can also review any and all the recordings that have been admitted. States 1 through 3, the recordings of the phone calls, and states number 4, Officer Garcia's body cam. And after doing so, at the end of your jury charge, there's this paper. I would ask that the foreman sign this section and return a true verdict of guilty in this case. Thank you all again for your patience this week.
Okay. Okay, ladies and gentlemen. You have heard the closing arguments. Hold on a minute. Okay, you've heard the closing arguments of both the state and the defense. Now, you're going to step down from the jury box, follow the bailiff into the jury room. I'm going to give the bailiff the charge. You're gonna bring the charge in there with you. And once you reach your verdict, there's some directions on the blackboard. You ring one bell if there's a question, two bells if there is a verdict. Mr. Bailiff,
Yes.
do you know where the bell is on the wall?
Yes, sir.
Okay, the bailiff will show you what a bell is on the wall. Okay, so the court is standing in recess until the jury reaches a verdict. Everyone, please stand. And if y'all need any water or coffee, just ring the bell and we'll get it to you. And there are some restrooms in there as well. There's a restroom in there as well. Court will be in recess. Open that door. Court will be in recess.
Hello.
Jefferson County Court at Law number 2 is back in session. The court is in session and call number M333-686. Case is filed in the state of Texas versus Victoria Laura Smith. Let the record reflect that Ms. Smith is present in court with her attorney, Attorney John Macy. Let the record also reflect that state is present with Assistant District Attorney, Attorney Andrew Hubel. I've received a message from the jury that it has reached a verdict. Will a bailiff please bring the jury into the courtroom? Everyone please rise as the jury enters the courtroom. You may be seated. Let the record reflect that the attorney for the state, the attorney for the defendant, and the defendant are all all present in the courtroom, and all the members of the jury is also present in the courtroom. Four-person. Have you reached a verdict in this case? Four-person?
Yes, Your Honor.
Is it one that is unanimous?
Yes.
That is one that is agreed upon by all the jurors?
Yes, Your Honor.
Okay, would you please hand that verdict page to the bailiff? Ms. Smith, would you please stand? And again, I would ask, is this a verdict that is agreed upon by all the members of the jury?
Yes, sir.
Okay. We, the jury, find the defendant not guilty as charged in information of abusive calls to 911 service. Does anyone like to have the jury polled?
No, Your Honor.
Would you like to have the jury polled? Okay, you may be seated. Ladies and gentlemen of the jury, on behalf of the citizens of Jefferson County, Texas, I'd like to thank you for taking time out from your busy schedules to be here these days. I know that this case was one that you paid a great deal of attention to, and we would like to thank you for that, for giving your considerations in this case. This will conclude your jury service. Now, one or maybe both of the attorneys may want to talk to you. You do not have to talk to them if you do not want to. If you want to, you can. If you don't want to, you do not have to talk to them. Now, again, if you need any, sometimes people need letters for their job or something like that, then our district clerk's office, which is right across the hall, is still open. If you need anything like that, you can go over to the district clerk's office. We will submit to the district clerk's office the names of the individuals, your names that is, who have participated in the jury service these past 2 days. Okay? And so we'll do that. But if you need anything else in the district clerk's office, you can go there and they should be happy to help you with anything that you need. Again, thank you for your time and attention. Now, anytime that you're in the area, that is, if anytime that you're in the area of County Court at Law number 2, you can have a seat in that area. We call it peanut gallery. And as I mentioned earlier, it doesn't mean you can bring peanuts in here and eat, but you can come and have a seat in your courtroom because this is your courtroom. I'm only a citizen and a public servant who is serving the citizens of Jefferson County. So anytime that you're in this area, you can come and have a seat in the courtroom to see what goes on in Jefferson County. And I know that by you serving, if this is your first time, I don't know if it's your first time or if you've been on jury and had jury service before. For those of you who are here for the first time, you got a glimpse of what goes on in Jefferson County. And for those of you who have served on juries before, it just gives you a little bit more understanding of our jury system or of our justice system. Now, our bailiff, she has some letters that she's going to give to you. If you feel free, you can drop us a line with any comments that you have regarding your experience here in County Court at Law number 2 the past 2 days. And again, I mentioned to the individuals who were on the panel that I normally give a handshake, but we still have COVID in our community. However, I give what is called an air handshake. So we give each one of you an air handshake and thank you for your services. And if you do not have anything else, you're released, and each and every one of you have a blessed day. We'll be in recess. And this will conclude the calling of the court's docket and conclude the calling of this trial in cause number M333686, State of Texas versus Victoria Laura Smith in County Court at Law number 2 of Jefferson County, Texas. Judge Terrence L. Holmes presiding. Everyone, please have a blessed day. Ms. Smith, you and your attorney will be given a copy of the judgment of acquittal. And once you get that judgment, you're free to go and you have a blessed day. And Mr. Macy, you're free to go. You have a blessed day. And Mr. Huber, you're free to go as well and you have a blessed day.
Thank you.
You're welcome.
See you all next week.